Good afternoon, everyone. My name is Lluc Cerda. I'm here today to answer your questions related to employment law, anything and everything that you can think of relating to how the law applies to your job, your situation at work, your recent termination. I'm happy to get to your questions as they come in today. I'm a senior managing associate for the Calgary office, the Alberta office of Samfiru Tumarkin LLP, and I'm happy to answer your questions today. We have a lot of information, of course, that we provide on our show here. Our next show after today will be on Wednesday, where Mr. Lluc Samfiru will be taking your questions from across the country. So feel free to tune in at that time as well. We also have a lot of information on our website. You can feel free to visit our website at any time, employmentlawyer.ca. That's employmentlawyer.ca. We have information on what your rights in the workplace are, as well as a nifty. I love promoting this little tool that we have. I think it's so interesting. A nifty severance pay calculator. So you can just go on our website, answer 4 easy questions, and we can advise you what we think are your severance entitlements if ever you are terminated. There's no obligation. We don't take down any of your information. You can feel free to just browse around, see what your entitlements might be, because a lot of people are surprised at how much severance they might be entitled to in Canada compared to other places in the world, compared to what you might hear or see on television. So it's always a good idea to know what your entitlements might be. That said, I've talked about this on the show already. I want to talk to you guys about a case that came down recently from the Court of Appeal in Alberta, recently, a few months ago, but it's important to remind people of this. So essentially what had happened is the plaintiff in that case, this was around when COVID started. COVID started and the economy tanked, and this person's employer was no exception. They had a lot of financial problems. And so in April, they decided to cut her pay, right? And then 6 weeks later, they terminated this person because there just wasn't enough work. So the termination was without cause. This person tried to get her severance, and she went to trial and was awarded her severance. But part of her claim was that, yes, she was terminated in May 2020, but she had also been constructively terminated in April when they cut her pay. And basically this went to the Court of Appeal as to whether this person had actually been constructively terminated when her pay was cut. So this can be a reason why you're constructively terminated, and this is why I bring it up. If something like this happens to you, as the Court of Appeal has showed us, it's very important that you reach out to a lawyer just basically right away. So what the Court of Appeal held was that when you're faced with a potential constructive dismissal, such as in this case, a reduction in salary, you have 2 choices. You can either quit and go after your severance. It's a bit more complicated than that, but you could say, listen, I'm not accepting this change. Pay me my severance. Or you can accept the change, right? You always have the choice to work for less money if you want, right? And what happens is if you do nothing, then after a certain amount of time, you'll be presumed to have accepted the change. So we always tell people this, like, if your salary gets cut, don't wait, 6 months to contact a lawyer. By that time, it might be too late. Well, 6 months, according to the Court of Appeal, is much too long. In fact, the Court of Appeal, one of the judges in the Court of Appeal said that, within 15 business days, so essentially 3 weeks, you have to make up your mind. So that gives you, 3 weeks to decide whether you want to keep this job that you've been working at possibly for years and years and years. Decide how you're going to pay your bills if you quit, contact the lawyer, get their information, have the lawyer draft a letter, and send that off to the employer in 3 weeks. So that's very short. But what I'm trying to say is it shouldn't take you 3 weeks to just make up your mind to reach out to a lawyer. If this happens to you, it's important you reach out to us as quickly as possible. If someone says, your employer says to you, we're cutting your pay by, 10 to 15 or more percent, important that you contact us so that we can talk, because you want to know what your options are. You might decide, well, listen, I'm willing to take the cut. That's fine, but do it with, the legal advice that you need so that you're making the appropriate decision. So you have our information there on the screen. If you have any questions about whether your employment has been constructively dismissed or what to do going forward, when your working conditions have changed, reach out to us. We're at employmentlawyer.ca. So that's the one bit of I wanted to talk to you people about today, because it's very important that you just not sit on this. I sometimes have people that call me, a year ago, and that's fine. A year ago you had a case, but today might be different. So reach out to us as quickly as you can. So we have a question here from Gene Smith. Gene asks, if your employer has given you a severance package and a short deadline, will they extend it if you talk to a lawyer? So that often happens, actually, Gene. And what I always tell my clients is this: firstly, yes, go ahead and ask for an extension. A lot of times, employers will give you a week or less to sign their offer, and if you don't sign their offer, my clients are afraid that the offer will be on the table. And that's very rarely the case, okay? Because even if they don't, even if they revoke their offer, it doesn't mean you don't have rights, right? You still have right to a severance. So in my experience, it's very rare that an offer gets revoked, okay? That said, it's always better to do the things the right way. So if you get terminated today, you have 7 days to sign, but it only takes you 8 days to see a lawyer. Go ahead and write to your employer and say, listen, I'm getting this reviewed by a lawyer. He or she's not available right away. Can I get a 1 week or a 2 week extension? It would be very hard for the employer to explain why preventing someone from getting legal advice would be an issue. So in practicality, it often happens. Yes, take that extra week, get the information you need, and we understand it's an important decision. Speak to a lawyer, get back to us after whatever it is, 2 weeks, 3 weeks. So it's very common to ask for extensions when you get this. So yes, absolutely. If you're considering the offer at all and you want to be able to accept it, but you also want to speak to a lawyer, then definitely try to get that extension. We have another question here from YouTube from Monique. I'm off on a sick day and will only be away for 1 day. My employer is requesting a doctor's note so he can monitor legitimate absences. Can they do this in Alberta? So it's not a great look for an employer to request a doctor's note for a 1 day absence. In fact, you're probably going to ask your doctor for it, and your doctor is going to send an angry letter to the employer saying, listen, we're overburdened right now in Alberta in terms of the healthcare system. There's better ways of dealing with this. But yes, theoretically, they can ask for the doctor's note. If you don't supply it, will you be terminated for cause? I doubt it. There are really some legitimate reasons why we shouldn't be overburdening the medical system right now in Alberta, across Canada, really. So I don't think it's something that's very wise for the employer to do, but it's not prevented under the Employment Standards Code at this time. So I would basically tell the employer what I just told you. It's like, you want to send me to a doctor in these times when everyone's overburdened, it's going to take me another 3 weeks to get an appointment to see a doctor, or I'm going to spend 24 hours in the emergency room trying to get this doctor's note. It doesn't make a lot of sense, in my view. So I would try to push back on the employers. Like, have you been reading the news? Do you know what's going on in the medical system right now? That's what I would push back with. We have another question here from Jennifer Bolton. Can your employer change your work days or hours unilaterally? All right. So Jennifer, I imagine that you're potentially working part-time or doing some sort of shift work. So it really depends. Depends a lot on how long you've been working the shift that you have. So for instance, if you've been working Monday, Wednesday, Friday for the last 15 years, and all of a sudden they want you to work Saturday, Sunday, Monday, which on top of it being a change, is a change to the, you're now working on the weekend, that could amount to a constructive dismissal potentially. What I invite you to consider is, did you sign an employment contract? If you did sign an employment contract, is there anything in there that's relevant? So for instance, you might have in your employment contract that your shift is Monday, Wednesday, Friday, or you might have something in your contract to the contrary, which says, the employer reserves for itself the right to change your employment, your days of employment or your hours of employment unilaterally, for instance. In which case, you've kind of agreed to it when you signed on. So it's hard now to say, well, you no longer agree. All right. So constructive dismissal claims, a lot of people tell me, I've been working this the schedule for a long time, and then you look at the contract, it says we have the right to change this whenever we want, and you signed that contract. So it makes it hard to argue that that's now not applicable. But in the absence of a contract, if you've been working the same shift for a long period of time, then you could say, well, listen, this is my shift. This is one of my job conditions is that I work this shift, not another shift. And you can make that argument that could amount to a constructive dismissal. Something that will be considered, of course, is the industry that you work in. If you work, for instance, in a factory setting, it could be that you might be moved to the afternoon or the evening shift. If you're working, for instance, in restoration, in a coffee shop or something like that, it might be, by looking at everyone else's shift being changed all the time, it could be that you were to expect that this could happen to you as well. Now, in terms of hours, I want to make clear that, a reduction in hours is equivalent to a reduction in pay. So if there is a change to your hours and it's a reduction, and it's a reduction of more than 10 to 15%, then that could amount to a constructive dismissal, especially if it's a permanent reduction, right? So yes, definitely, if that's an issue that you're having, you should reach out to us, see how we can help, whether you've been constructively dismissed. And if it's a combination of the two, whether they're changing your shift and reducing your hours, then that definitely could amount to a constructive dismissal, in which case you have the opportunity to refuse that change, and then you can go after your severance. Now, we have another question here from Heather. My employer recently cut my hours and restricted my access to the office. My key fob was disabled, and now I have to get him to let me in. I haven't resigned, but can't continue to work like this. Is there anything I can do? So, Heather, what I gather, what I think is most important from what you just said is that there was a reduction in hours. All right. So if the reduction in hours, as I was just saying, is of a sufficient degree that it affects significantly your compensation, then yes, you've been constructively dismissed, and you should speak to us to help you get your severance package at this point. The ways in which you access the office, I need to know a little bit more information on why that's an issue for you. Why, instead of having a key fob, contacting your manager is problematic. Is it that your manager doesn't answer, so you're waiting outside for 30 minutes in the freezing cold that we're having here? That I could see being an issue. But is it just that you don't like the way you're being monitored? I'd have to know more what the issue is with contacting your manager to be let into the building. But the hours, if the reduction in hours is significant enough, that can amount to a constructive dismissal for sure. We have a question here from Reggie. I was recently let go from my position just after probation period ended. They only offered me 1 week. Is that a fair offer? So, Reggie, what I think you were offered is your minimum entitlements under a law called the Employment Standards Act, or the Employment Standards Code, as it's known here in Alberta. So basically, it's just that. It's an absolute minimum. No one can get less. For that to be fair, though, the only way that's really fair, in my view, is if you've signed an employment contract that has a termination clause in it. Termination clauses are in a lot of employment contracts nowadays, and the point of the clause is to limit how much severance you're entitled to when you're terminated. So I would say that 3 months and a few days is a 1 week is not enough severance. All right, severance is there to kind of tide you over till you find a new job. How many people find a new job in 1 week, right? So 1 week is definitely not enough in my view. But we'd have to check your employment contract to see if there's an enforceable termination clause. If you do review your employment contract and you're like, oh yeah, there's a termination clause, I don't want you to think that you're dead in the water by any means, because a good 90% of these clauses are not enforceable. All right, a good 90% of them are improperly drafted, poorly drafted, illegally drafted. And when that happens, then a judge will say, well, this clause is not enforceable. It doesn't limit Reggie's entitlements to severance. And I'm going to decide what I think is fair. And a judge is probably, in your case, depending on what kind of work you did, probably going to give you probably in the range of 1 to 6 months of severance. Really, it's a big range, but I really don't know much about much else about you than the time you've been at the company. So definitely, if you see, you've just been terminated, you're reviewing your employment contract, there's a clause, have it reviewed. All right. That's the most important message I want to get across to you today is have us look at it, because we're experts at invalidating these termination clauses. We do it all the time. I was recently in court in Ontario and got a termination clause invalidated in a very kind of novel way. This is really the cutting edge of employment law, is trying to find holes in these termination clauses, and we're very often successful. So don't just give it a read and say, well, okay, I'm screwed. You're not. Give us a call. We'll let you know what we think we can do to help. We have another question here from Jen. I was let go for cause because I was unable to adhere to scheduled breaks for medical reasons. I gave them notes from my endocrinologists, but they still fired me with cause. Do I have any rights in this situation? So, Jen, I do think you have rights. Absolutely. If you have to take time off to see a medical expert, the employer has a duty to accommodate that. All right. Firstly, you should try to make your appointments outside of working hours. But if that's not possible, it's often not. If you work 9 to 5 and your doctor works 9 to 5, then you have to, meet them between 9 and 5. So if that's the situation, then your employer has a duty to accommodate you to the point of undue hardship. Absolutely. And so the termination is firstly not a valid cause to terminate someone. Secondly, is a human rights violation. All right. So that really opens up a lot of potential risk for the employer, or exposure to damages for human rights violation, to severance payments being owed. You might even be able to get your job back and get back pay, and just a lot of stuff. So Jen, feel free to reach out to us. We're at employmentlawyer.ca. I think that you probably have a strong claim here based on what you just told me. I'd like to hear more about what actually happened there, to give you a more informed opinion on what your entitlements might be. So definitely feel free to reach out to us. We have another question here from Suzette DaCosta. Can an employer force you to work on the holidays? Okay, so this is a hot topic here in Alberta, with Christmas falling on a Sunday. Now, what's important to realize, first thing I'd ask you, Suzette, is are you generally working on these days? So Christmas Eve and Christmas, as well as New Year's Eve and New Year's, fall this year on the weekend. So for instance, if you're normally scheduled to work on the weekend, it could be that you have an obligation to work on these days that are otherwise holidays. So that could be the obligation that you have to work if that's your regular schedule, and for whatever reason, the employer is not closing down. It could be, for instance, a 24-hour shop, or it could be medical establishment or something like that. It needs to be open 24/7, 365. So in that case, the shop stays open. That said, if you're regularly scheduled to work on a Sunday is Christmas, and you work on Christmas Sunday, then essentially you're going to be entitled to statutory holiday pay, as well as pay on top of that. All right. So you should be making about two and a half times your normal salary for the time that you're there. All right. So definitely, if you're working on Christmas, realize you're owed compensation during that time in terms of additional salary. All right. So what I would tell you is, if you're not usually scheduled to work on Sundays, and they want you to work on Christmas Sunday, theoretically, that's not your schedule. At the same time, it kind of depends on what kind of job you have for me to help you determine whether you have an obligation to work. Generally, when you're scheduled, you have an obligation to work. Otherwise, that's kind of a no-show. It's not the best procedure to be scheduled for a shift and just not show up because you refuse to work it. Working one day out of your schedule is not enough to amount to a constructive dismissal, in my view. So you definitely want to work with the employer to see how you can get out of working this day. You might have other obligations, whatever they are, that might prevent you from working. You need to explain that to your boss and have an open dialogue with them about that. We have a question here from Terry. My employer has told me that they cannot accommodate my service animal in the office because of allergies. I'm not sure what to do. I need my service dog with me. What can I do about this? That's a very interesting question, actually, because it seems to conflict two disability requirements. So on one hand, you have a disability that requires that you have some sort of service animal. At the same time, there are other people in the office that have an allergy. I don't necessarily think that an allergy to dogs rises to the level of disability, but suppose that it does. Now the employer is stuck between how do I accommodate both these people? So the reality is it's not up to you to decide how to accommodate yourself. It's up to the employer to figure it out. If the employer has decided that it would cause them undue hardship to try to accommodate you, then your recourse is to go to the Human Rights Tribunal, to the Human Rights Commission, and have them review that decision, right? If you have a need to have a service animal because of your disability, then you need to enforce that right. So basically, I would say it's not your concern if someone else has an allergy. It's not up to you to figure out how both of you can coexist. That's the employer's job, all right? What you need to do is essentially stick to your position and say, I need the service animal, I need to be accommodated, all right? So if that's becoming a trouble for you, if they're trying to brush you off, what I always tell people, if you have a restriction, if your doctor or someone else has told you you have a medical restriction, it's important that you not waver on that, right? If someone tells you, you can't live over, if your doctor tells you can't live over 20 pounds, your employer puts a 25-pound weight in front of you, it's important you tell your doctor, I cannot lift that. It's, you can't try to be a team player all the time and say, well, I'll try. Don't lift it. If you say, I need to come in with my dog, don't go in without your dog, right? Do things the right way, and the right way sometimes means contacting us, contacting a lawyer, so that we can straighten this out for you, all right? Because people trying to compromise on their restrictions only affects their health and doesn't improve anything in the workplace for anyone. So if you're having trouble getting your employer to, make reasonable consideration of how they can accommodate you, I suggest you contact us. Reach out to us. We're at employmentlawyer.ca. All right, employmentlawyer.ca. We'll be happy to talk to you about how we can help you get the accommodation you need to stay in your job. Jennifer Bolton says, thank you so much for your answer. That's my pleasure, Jennifer. Anytime, if you have any further questions, like I said, I'm here for the next 5 or 6 minutes, but we have Lyor Samfiru as well coming in on Wednesday. So feel free to drop in then. He'll be taking your employment law questions as well. So we'll have plenty of time to answer as many of the questions as we can here. So that's at 1 p.m. Eastern time. All right. So we're currently at 1:30 p.m. Mountain time. So just adjust, for the time zone. But 1 p.m. Eastern on Wednesday. We have another question from Suzette. I work in a factory, but have standard Monday, Friday shifts. They put me on to cover other people's vacation requests. I didn't block the time off because it's not a day I normally work. I see. So Suzette, if I recall, oh yes, there we go. So Suzette was the one who had asked, can an employer force you to work on the holidays? Okay. So so Suzette, what I would say is that's I don't really understand how that happens. If you work Monday to Friday, why would they think to book you on Christmas? It doesn't make a lot of sense if Christmas is a Sunday. I would say speak to them about this. I mean, why would you have to book off a day that you already have off? It doesn't make any sense. Let me know if you at any other time work on weekends, because I don't see how they would think that. At the same time, what happens is if you don't show up on Christmas, to work the shift that they scheduled you, you could face discipline. All right. Am I saying that you're going to be terminated for cause? I don't think they would have cause to terminate you, but they might have cause to issue you other discipline, including maybe a verbal or a written warning, maybe even a suspension with or without pay. And of course, that then creates a chain leading to ever more increasing discipline. So I would say try to have a dialogue with your employer about this, but I know it's very frustrating to be told to work on Christmas. Even more frustrating, though, to be disciplined for not having come into work on Christmas. This reminds me also, if ever you are disciplined, if you're disciplined with a verbal warning or a written warning and you don't agree with the discipline, it's absolutely fine to put in your version of events, to write down as Suzette you might, if you get a written warning or something like that. Listen, I didn't book this day off because I don't work Sundays, right? I mean, why would I book off a day that I don't work? It doesn't make any sense. So this requirement that I work and this discipline I'm getting for not having worked, I don't agree with that. Because eventually, down the line, you might do something else, and then there's a progressive discipline policy in the workplace, and they might say, well, you already got this written suspension, and then we suspended you for something else, and now we're terminating you for cause. And so they've gone through their procedure, but maybe that first written suspension, a judge will find that wasn't appropriate. That shouldn't have been a written suspension, in which case the termination isn't appropriate as per the policy either. So definitely good piece of advice is, without being confrontational or rude or whatever, if you've received some form of discipline and you have an alternate side of the story that you don't think was heard, put that in writing and tell them, I want this included in my employee file along with the warning, all right? So that it's there in the future. Of course, if you never tell anyone that you have an issue with the discipline, it's a bit hard to contest it, months down the line or years down the line when it's escalated to something bigger. If you do it right then and there, that's the best time to do it, all right? So, I guess what I'm saying, Suzette, is consider writing them a letter that you ask to be included in your employee file on why you don't want to work on this day and why you didn't request a day off. Because I think that this is, you're being kind of railroaded here, you're getting steamrolled. And I don't think it's fair to you to have to work on Christmas when you work Monday to Friday usually. We have another question here from Sharmila. I was recently let go from my sales position. My employer had said that since I was not employed for the end of year bonuses, I'm not entitled to it. Should I still not get paid out for this since I worked the full year? So that's a very interesting question, actually. So I'll rephrase it for our listeners. So essentially, you work January 1st to December 1st, and you're terminated December 1st. Had you not been terminated, you would have worked the full year, and the bonuses would have been paid in March, for instance. All right. So are you entitled to the prorated bonus from January to December? Absolutely. In my view, there's a lot of case law supporting that you should at least get the prorated bonus. But not only that, imagine you've been there, let's say 5 years, Sharmila, and you're owed, just to use a number, 5 months of severance. So you're terminated December 1st, and you're owed 5 months of severance. What that means is the employer has to cover all the salary you would have earned for their ensuing 5 months, which gets you to April 1st, right? So the bonus would have been paid in March, right? So you should get not only all the bonus for 2022, because it would have been paid in March, and theoretically, had they not terminated you, instead they had provided you with working notice of 5 months, you would have been working when the bonus was paid. So definitely those amounts are owed to you, in my view, including, there's a lot of case law to support this as well, that those first 3 months of 2023, you should get the prorated bonus for that as well. We just recently had a decision to that effect from the Court of Appeal of Ontario, right? So definitely something you want to push back on, or get our help to push back on that. Definitely something you want to think about before you sign any documents that they presented to you at the time of your termination. So reach out to us. We can review your employment contract, your termination letter, your bonus plan, all of that. We have a lot of I look at these, weekly, daily, really, and we can let you know whether they comply with the law or not. All right, so feel free to reach out to us to have all of that reviewed. So that I suspect is probably, especially in sales, that's not a small amount of money. So definitely reach out to us. There's a lot at stake. So we're at employmentlawyer.ca. My name, once again, is Lluc Cerda. I'm the Senior Managing Associate of our Alberta office of Samfiru Tumarkin. I was here today to answer your employment law questions. I think we had some really good questions today. I thank you all for posting them. Like I said, we're back on Wednesday with Lior Samfiru, who's going to be fielding your questions. So feel free to tune in right before that. And I will be back in a couple of weeks. All right. So I hope to see you then. And we'll, if I don't, enjoy your holidays. We'll see you then. Bye now.